That's right. Now, here to discuss is defense attorney, former head prosecutor Bob Bianchi. And Bob, you and I have been texting. We've been talking with Michael about this. I think it's driving you a little crazy because I would have to assume that in this particular state that we've been watching, the Commonwealth of Massachusetts, that it starts over at the very beginning, meaning they're having these motions hearing for experts that have already testified at the first trial.
Oh, Judge, wow. Yeah, we've been texting back and forth. I think I may have called it lunacy, legal lunacy, this hearing. I don't understand it from a legal point of view, and I don't understand it from a tactical point of view. Okay, let's take it from a legal point of view. Daubert is the standard, and this defense lawyer, really like him, like his presentation, he's right on point, goes to admissibility, not the weight of the testimony. That's for the jury to determine what level of credibility they're going to give or not give. The judge's role here, is it worthy of even being admitted? And it's such a low standard to admit expert testimony. Let's not also forget that this judge has already ruled that this testimony is admissible and was allowed to have been testified to in the first hearing. I was telling you when I was texting you, in my state, that's called law of the case. You wouldn't even get a crack at another hearing because the judge has already ruled on this. So that's the two legal issues. The judge is going to allow the defense because the defense was right. They have the right to put on a defense. But what I don't understand tactically is, boy, Judge, prosecutors are running scared here, aren't they? You can smell it in the motions. You could smell it in them trying to prevent the defense from putting a defense on. And as a former homicide prosecutor who never lost a case on appeal, I would never make this motion as a prosecutor. Why? Because I know I'd be putting the case in jeopardy, that should there be a conviction, it's going to be reversed on appeal for the very reasons the defense stated, for not allowing them to put the defense on. This shows me, again, from the prosecution standpoint, sorry to say it, guys, amateur hour.
Well, let me ask you this, Bob, because, you know, we were talking a little bit about why they would do it, because I agree with all the reasons you said, and I posited that it could be there's a public relations part of this, because I can say, listening to the cross-examination, they went through great pains to point out all the things that do not fit the idea that these were dog bites. And I'll tell you what, there were some things that I had gotten from the first trial, and as I'm listening, I'm saying, you know what? There's a lot of evidence here that suggests maybe this was in fact involving a car and not dog bites. And you know how much this community has been into this trial. They know it's going to be televised. Maybe they're working public opinion at this point.
Wow, Buck, that's a great, I mean, that's a really good observation and an important observation to make. So let's break that down a little bit. The first piece to that is the fact that there could be alternate explanations, or that the dog bite testimony or dog attack testimony is completely wrong, goes to the weight of the evidence that the jury can disregard it upon a vigorous cross-examination by the prosecution. The second part is the court of public opinion. When prosecutors walk into the arena of the court of public opinion, and I've been a prosecutor a long time in my career, you are walking into an arena you don't belong. You're walking into a dangerous space. You need to remove yourself from how the public thinks about a case. And this is one of the reasons I have a big problem with elected district attorneys, because too many times they're worried about how the vote is going to look as opposed to what the right thing to do as a matter of law and fact. Last point. If I were the judge, if I were the prosecutor, another reason I wouldn't do this is I think they're losing credibility points with this judge. They already made the motion. They lost previously. It was allowed to be testified to. We all know it's going to be admitted. Who cares what the public thinks? This is a court of law, not the court of public opinion.
Well, I want to add one more thing that may be a strike against the strategy here, and that is it a mistake for a prosecutor to really give a witness the experience of an aggressive cross-examination? Because he was very aggressive with her, and Michael and I were talking about maybe now she's going to go look back at the points he made to be better prepared for trial when it comes around if she's allowed to testify.
Judge, 1,000%. You are 1,000% correct. That's why many times, this is why it doesn't tactically make sense. Not only creating an appellate issue, thank you for bringing that up. As a prosecutor, when I'm looking at this, I know the judge is going to admit this testimony. Why save your powder? Keep it dry now. You're giving the defense witness now an opportunity to understand all the weak spots, to your point, be able to prepare, knowing that this is going to come when it really makes makes a difference. When you're at the dance, that is when you're there with the jury, because they're the only thing that matters at that point in time. So you gave the defense a free opportunity at knowing where you're going.
I agree.
Yeah, I would agree too. But again, that's the reason I think maybe there was some larger issue. And I take your point, Bob, that perhaps prosecutors shouldn't be thinking that way. This is an interesting situation.
It's a public case, for sure.
It's a very public case, and the public has been against the state's position in most instances. So back in our guest defense attorney, former head prosecutor Bob Bianchi, to discuss. And Bob, this is a preliminary hearing. The idea is the state has to present enough evidence to move this on over to trial. A very low standard, basically probable cause in most jurisdictions. Talk to me about, as a former prosecutor, what your strategy is here. This is going to take place over the course of 2 to 2.5 days. Normally, you don't need that much in order to reach that low standard, but in some instances you do. This is a circumstantial case. That may be why.
Yeah, so it's funny. Each state has a different procedure with regard to this idea of probable cause. Like in New Jersey, we don't have it. We go before a grand jury. We have a judge issue a complaint based on probable cause, and that's the process. Here, there's an actual court hearing. So the trick for prosecutors, whenever you're doing a preliminary pre-trial motion, is to get enough evidence out there in order to meet the threshold or the standard that you need in order to establish, as you've indicated, that very low level of probable cause to believe a crime is committed, but not to present all of your evidence. We were kind of talking about that before in the previous segment. You want to keep your powder dry. You don't want to give too much information in the preliminary stages, but you want to give enough to the court so that they can go forward with the case. And that's what prosecutors are doing right now. And you're right, Michael, the more circumstantial the case is, which simply means you're inferring guilt based on a number of different facts, not direct evidence. It's inferential. You got to kind of give a little bit more to the judge in order to make a solid record.
Bob, does it make it harder to prosecute an individual who's an alleged repeat sexual perp who has people on his side, including the mother of his 5 children, saying he's a good father, and people that are painting a picture of him as a likable, normal guy, which, given the allegations, I would argue isn't true?
Yeah, I don't think that's helpful to him. And the more importantly, legally, the more that he puts out there, or the defense puts out there, that he's a good guy and he wouldn't do it, the more likely, evidentially speaking, the court is going to allow prosecutors to introduce what they call 404B evidence, which is other act evidence. In this particular case, there are at least 2 other alleged victims of this individual, and there'll be a decision as to whether or not prosecutors are going to be allowed to introduce that evidence in order to use 404B evidence to rebut, for example, any allegation that he has of good moral character. And when you're ever introducing 404 evidence as a prosecutor, you're nervous because courts don't like to have a whole trial based upon other allegations than the one that's being typically prosecuted. So the more they open that door, the more likely prosecutors will be able to admit the bad stuff.
Oh, great legal points. Thank you, as always, to Bob Bianchi for joining us with your great expertise.
Folks, stick around.